This TV show is made available to provide general information and a general overview of legal principles. Viewers should not rely on the information provided without consulting an attorney who is licensed to provide legal advice. Topics and ideas shared on this show are not to be used as a substitute for legal advice from a licensed attorney in your state.
Welcome to Under Oath with Michelle Bell. I'm your host, Michelle Bell. I am a licensed attorney, and on this show, I bring other attorneys on and we give you, the public, legal information without that consultation fee. Now, I like to start the show off with a segment I call Jury Duty. And this is similar to trivia, where I give you a question, and the first person to submit the correct answer through the website will receive a gift and your name on the website. Now, you ready for that question? Okay. Al Capone was sentenced to 11 years in federal prison for what crime? You can submit your answer on our website, which is www.mbunderoath.com. Now, you also subscribe to the website and check out our social media handles. You can look us up on Facebook, YouTube, Twitter. We're on all of it, okay? Now, don't go anywhere. We'll be back with our guest.
I understand. I know it's not your typical resume.
Okay, well.
But candidate. But I've been working double shifts just to pay for books. I've been raising my 2 little brothers. I'm determined, driven, motivated. Isn't that what you're looking for?
Look beyond the resume and discover new ways to develop great talent at gradsoflife.org.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. Now today, we're going to be talking about employment law, and I have a surprise guest for you. Ta-da! It's me. So yes, I am a licensed attorney, and one of my areas of practice is employment law. I also deal with civil litigation, excuse me, personal injury, health care, like Medicaid, Medicare, home health issues, and beverage law. But today, we're going to go into employment law. So I am what you call a teaching attorney. So when clients come into my office, there is homework. If I decide to take your case based on what you've explained to me in the situation, I do give you homework and I explain things as we go, because again, no one cares about your case more than you, because it is happening to you. So you need to be involved and not leave 100% to me as the attorney, who's someone coming in and only knows that situation that's handling. So employment law includes a lot of different topics and subtopics. It can be very complicated. So there's going to be more than one show on employment law. So what I'm going to do is, this is going to be part 1. And the topics that I'm going to deal with today basically deal with once you're terminated. There are, areas where if you're demoted or you were suspended, put on probation, and you wanted to appeal those decisions, those will be discussed at a later date. But today, this is more on the termination. So part 1 will deal with from the employee's perspective, and part 2, which will be another show, I'll actually deal from the employer's perspective. So I will keep it basic so that everybody will understand, and we'll just get right into it. So I am going to treat this as if you walked into my office. So this is what you'll see, me with the tablet and some notes, and I write during that. When you come in, most people that come in for employment law, they are the ones that are just very upset because they've been terminated from their job. And most people have been on their job for a minimum of 5, 6, 7 years, the ones that come into my office. And those that have been there for that amount of time, some have been 20 years, some have been 25 years, some in the private sector, some are in the government sector. And it's devastating because they've spent majority of their time at their employer. And they just don't understand how they could just be terminated, whether it's for cause or without cause. And they don't know what to do. So they're very, very, very devastated. So the first thing that I like to tell them is, okay, when did you get terminated? And the reason why I ask that is because there are statute of limitations, meaning there are time frames that you have to pay attention to if you were wrongfully terminated, and for the reasons that can come up, and you legally may be able to take action against your former employer. But it doesn't matter if you take so long. Now, I understand you get terminated and you're devastated, so you're not even thinking about a time frame, what to do. You're just like, oh my goodness, this has happened. And it takes a while to process it. Understood. However, process it a day, maybe 2, and then you have to get right into it. If you're going to appeal it, or you think that you have a case, you need to contact an attorney. If you're not sure if you want to speak to an attorney just yet, do your research. I mean, you can start off with a regular Google search and find out, okay, I think I was terminated wrongfully, and this is what I think happened, this is what came up, and a whole lot of different things will come up. If you are part of a union, then, speak to your union representative, preferably right after you've been terminated. If you are not a member of the union, then reach out to an attorney or try to find a free legal service that's in your state. Now, I am licensed in DC as well as the federal courts in Maryland. However, if you are someone that's watching this show or someone has told you about this show and you have a question and you're in a different state, it's okay. Contact the show and I'll try to get your information to an attorney that's in your state. And we'll give you that attorney's name, maybe 2 or 3 attorneys' names. And then you contact them and see, what can happen from then on. Again, you can contact the show, which is www.mbunderoath.com, or send an email, which is mbell@mbunderoath.com. All right, now getting back to, you've now come into the office. Hopefully by then you've gotten to a point where you can actually discuss being terminated. Some people, they take it really hard and they can't talk about it. But again, you have to be aggressive at this point. You were terminated, take your day or 2 to get over it, or at least get to a point where you're like, okay, this was not right. I don't know if I have a case against my employer, because yes, you may be in an at-will state or jurisdiction, but at-will is not absolute. There are exceptions to that. And that's where you'd want to reach out to an attorney to talk to you about it. Now, if you believe that you were terminated for a reason, but your termination letter only says that you were terminated and that's it, because again, if you're in an at-will jurisdiction, they don't have to give, your employer doesn't have to give you a reason. They can just go ahead and terminate you. Now, if they do put a reason in your termination letter and you feel like, no, that's incorrect, that's not right, or I was discriminated against, or they wanted me to break the law in some way and I didn't want to, and that's why they terminated me, even though on here it just says that, you were terminated because you were late 10 times out of 3 weeks. But you don't believe that's what it is. You need to have proof of everything that you're going to claim. So if you're going to claim that you were discriminated against, you need to have proof of that. 9 times out of 10, your supervisor, manager, or whoever is above you at your employer, 9 times out of 10, they will not have put, something that's basically discriminate against you in an email or a written form. But you may have been one of those that documented everything. Maybe you kept all your emails. Maybe you kept a journal of everything that was happening. Maybe you're someone who actually, every time something happened, you went to another manager or another supervisor. You went through the chain of command, or you went to HR. All of that stuff, that's documentation. That's a paper trail that you're creating, and that is for you. That may help you with your claims. Now, will everything be a claim? Will everyone be able to have a case against their employer, because they were wrongfully terminated? No. There are exceptions, like I said, to the at-will jurisdiction. There are different things that will allow you to have a case against your employer, but not everything will be considered enough to do that, which is why you need to, speak to a attorney that's licensed in your state or jurisdiction, okay? Now, one of the things, and I'm just looking at my notes here to make sure that I go into the information I wanted to give you. So once you have your termination letter, you come into the office, you fill out the intake form, I get more information, then we get into whether you have a case or not. And if you are part of a union, you should go to your union. If you are not part of a union, then, definitely go speak to an attorney. You may have to pay a consultation fee to speak to that attorney. If you do, it is well worth it. And the reason why, the person will let you know during that consultation whether you have a case or not. Because remember, I said there's a statute of limitations, depending on if you have a case. So if it's a contractual issue, meaning they were terminated, but you felt like that termination, breached what was in your employment agreement or your employee manual, things like that, then you may do a contractual, it may be a breach of contract. If there was a claim that, your employer terminated you, but you feel like they terminated you because you did not break the law and they wanted you to break the law, now you're going into a tortious claim. And in DC, there's a 3-year limitation on that, and every state has their own statute of limitations. However, for example, if you are part of a union, though, there's a shorter time window, especially like here in DC, of where you can file your claims. Depending on which court you go to, you may have a 10-day window. You may have a 30-day window. It's all different depending on where you are. Now, after you've talked to an attorney, to make your time beneficial during that consultation, and yes, you may pay a fee or you may not, depending on the attorney, they'll let you know. To make your time more efficient and, just give you the most information, come with your questions already. Don't just go in there and wing it. Be prepared. Have your documents with you. Have your questions already to ask that attorney about what happened. You should already have a summary of what took place, and you don't need a soliloquy. You don't need an introductory paragraph or transitional sentences. You don't have that much time. If you're paying for 1 hour, you need to fit everything into that 1 hour, and you also need to allow time for the attorney to answer the questions and give you the information and tell you whether you have a case or not. So be prepared. Don't just walk in there and think you're gonna wing it. Don't do that. Use your time and money wisely. That will let you know whether there will be additional steps that you can take. So at this point, we're gonna take a break. We're gonna come back with office hours and more on employment law and what happens when you're terminated. We'll be right back.
Okay, so what would you bring to my company?
What do you need?
I need problem-solving skills.
I got through high school without a car, a phone, or a computer.
No college degree, though.
Not yet, but life's taught me a lot, and I'm ready for more.
Well, you're not the typical kind of candidate that I hire. But you are exactly what I'm looking for.
Your company could be missing out on the candidates it needs most. Learn how to find a great pool of untapped talent at gradsoflife.org.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. And today I'm also your surprise guest, and we're talking about employment law. So now we're gonna move into the segment of office hours. And there were 2 questions that were sent to me by email, so there isn't a video or audio, and I'll answer them the best of my ability. Okay, we ready? All right, first question. I was just terminated and no lawyer I spoke with will take my case. What do I do? Well, what you can do is do a Google search for free legal clinic type services. Sometimes the court may have a pro bono department or a legal clinic, or a legal service for people that do not have any money or are low income. And technically, if this was your full-time job and you were terminated, you may fall into that category. Sometimes you can call, different resources are on the computer, and you can look for that. The court may have it, or just do a regular Google search, honestly. Second question. I use my work computer to check my personal email, just like everyone else out in the office, but I was terminated for it. Can I sue for wrongful termination? Well, if your employee manual says that you cannot use your work computer for personal reasons, then you cannot use your the work computer for personal reasons. Whether other people in the office are doing it or not, you can't do it. When you agreed to work there, you saw the manual, more than likely you either signed something saying that, an acknowledgement saying that you saw and read the manual, or you're actually signing the manual. Each employer does theirs a little differently, but if it says in there that you cannot do that, then you cannot do that. And being terminated for it, your excuse can't be where everybody else was doing it. It's not gonna help you. So, and those are the two questions that I have. So, but they're great because now they segue into what I wanted to discuss next. Now, we left off with you speaking and being prepared when you have your consultation with an attorney. During this consultation, you have to be honest with the attorney. Now, if the attorney decides to take your case and you sign your engagement letter, which is the agreement between you and the attorney, read it, make sure you understand, because these are the terms of, the attorney representing you in this matter, and you need to know what's going on. Be honest with your attorney after that. One of the things that people don't understand is a surprise during trial or in court, it's hard to recover from. So definitely be honest. Don't be afraid. I understand some people are upset because they're like, well, he doesn't need to know this. My attorney doesn't need to know that. They just need to know that this and this and this occurred. So you're selecting what information to tell the attorney. You're putting the attorney at a disadvantage. Tell the attorney what you need to tell them. Just tell them everything. Be honest with them. Answer their questions truthfully. And then they can better prepare their case. Because what you don't want is to get into court and then information doesn't come out like you want it to, and then now you're upset. Because, well, you didn't say this and you didn't say that, and you're upset with the attorney. Well, how would the attorney know if you didn't say anything? So it's okay. Be honest with your attorney. You've signed the engagement letter. They're now the attorney representing you. Let them know, okay? Now, a lot of people that I've dealt with when they come into my office, we've had some main issues that have occurred once, we decided that they do have a case. And one of them is that they receive a letter saying that, there are also breach of contract claims. And when I say breach of contract claims, it would be that they terminated the person because they did something that they weren't supposed to do, and it was listed in either the employee manual or the employee's contract or a non-disclosure contract or a confidentiality agreement that the employee signed when they first started working at the job. Key point, read these documents that you are signing when you first get on the job. I understand it's great. You love what you're gonna do. You read the job description. You love the salary. Everything about it is great. The health insurance is awesome. Okay, but you need to read all those papers that you're signing because you're agreeing to it. So you're saying, I'm not gonna do this. Now, you end up doing what it says not to do, and now you have like a breach of contract. So a couple of the things are that have come across my desk, and me speaking with potential clients and people who have signed on. You may be upset. I get that when they let you go. But you cannot say, well, I've worked here for 25 years, 30 years, and walk off with the employer's property. If they gave you a BlackBerry, a cell phone, whatever that is, a laptop, a computer, documents, all that stuff, you cannot walk off with it. You can't get mad and just say, well, you know what? And you just put your little zip drive in and just start downloading documents and information and take it with you. No, don't do that. Don't do that, okay? This is the employer's property. You cannot take it, you cannot destroy it. We've had people who were just angry and just literally took stuff and swiped it and threw them on the floor, and they're like, well, I'm getting fired anyway, so what's the big deal? It's a big deal. Don't do that. You're destroying their property. Don't do that. Another thing we have is the failure to maintain confidentiality. You cannot, I understand you're upset, but you cannot just start telling the employer secrets, especially if you signed a confidentiality agreement. Now, remember, it may not be a separate document. Some employers have a confidentiality agreement and it'll say that at the top and it's a separate document. Some employers have it as a paragraph in maybe your employee manual or your employee contract. That's why I tell you, read everything. So if there's a confidentiality agreement or clause or paragraph in your documents, it's telling you you cannot give certain information to people. You cannot discuss it with others. That means you get upset, you cannot go running your mouth and telling all confidential information. You can't do it, especially when you agreed to do it and you signed off on it, okay? That will also cause a breach of contract issue. Then we have what we call the breach of a non-compete clause. That means in some positions, there's a non-compete clause or a non-compete compete agreement that you may have to sign. And that just means that you cannot work for certain competing businesses, and it's for a specific amount of time. It can't be like infinite. Like they can say you never could work for this person. So for example, if you work for Coca-Cola and they say, okay, in the non-compete clause, you can't work for a competing company, which in this example could be Pepsi, you can't work for them within a year from when you leave Coca-Cola. They can't say you can't work for Pepsi ever after you no longer work for Coca-Cola. No. But again, these are things that you need to see and read and agree, because again, when you came on and you signed these documents, you agreed that you wouldn't do that. That will also cause a breach of contract issue that may come into play with getting you terminated. Another one is, yes, you've been terminated, you go somewhere, like for example, if you work for a home health company and a home health agency, like someone who sends aides in to assist with a family member that may not be able to do normal functions like bathe, cook for themselves, stuff like that. A lot of companies, there are agencies that have aides that come in the home and help the person who can't do everyday function or everyday activities. Okay, sometimes those aides leave that agency and go to another one. If you do that, you cannot solicit other aides or that beneficiary to come with you. You're not supposed to do that, especially if you sign an agreement saying you won't do that. So that's an example. Again, that can be a breach and cause for a termination. So that can be an agreement you had, or that can be a term that was in one of the documents that you signed. Don't do that, especially if it says that. And then we have what we call a breach of non-disparagement clause, meaning in layman's terms, can't say negative comments. about your former employee. Even though they've terminated you, you cannot go on social media and just trash the company. If you signed an agreement and it has that in there, you cannot do that. I understand you're upset. I understand that's your personal page and you feel like you can say whatever you want to say on it. No, don't do that. Because there are ways to see that. Yes, that is your personal page. But that does not stop other people from taking a screenshot of it. That does not stop other people from viewing it from someone else's page. I mean, you know how social media works. So just be careful. Or you can't be outside, well, I'm talking to my friend at lunch and, you're just trashing the company. You have no idea if the person sitting next to you over there or anybody who overhears knows that company, knows anybody who works there, may know you and you worked at that company. You don't know. But if you sign something that says that you can't do that and you went ahead and you're doing that anyway, yes, there can be a breach. Now, this is while you're working there and, if the clause says that even after termination you can't do that, then you can't do that. Now, some employers, they also include it in, where you can't do it and they can't do that about you. So if you're sitting somewhere and you see your supervisor and they don't see you, but you hear your former supervisor or current supervisor talking trash about you, and you know that was a clause in there, say something. Not to the supervisor, but to the proper chain of command. You can do that. So these are just examples of how, there can be a breach of contract. So just be careful of those things. These are also some reasons why some people were terminated. If the agreements say you can't do it, don't do it. So at this point, we are going to take another break. We're going to come back. And I did receive some questions for Plead the Fifth. I have not viewed them. So what you're going to see is my honest answers. Okay? We'll be right back.
It's a big responsibility.
Oh, it's huge. I know, it's huge.
And the salary.
Oh my god, yes. I mean,
Right?
I was about to move in with my parents, and right before, so this saved me.
I really believe in you,
Thank you. It's nice to hear that from someone.
These are cool. Did you, what did
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. So we're going to move right into one of my favorite segments, which is Plead the Fifth. There were questions submitted, and I did not look at them. I don't know what they are, so you're going to get my genuine reaction. All right, first question. Have you ever done anything illegal? Yeah, that's a Plead the Fifth. What's your favorite movie? Love Jones? Do you enjoy employment law? I do. I actually enjoy employment law. I really do. Fighting for what's right, depending whether it's the employee or the employer. Where did you work in high school? Well, I am originally from Brooklyn, New York. Yay, born and raised. And I was a slacker. I didn't work in high school. And what was your first job? Oh, gosh. My first job was I worked for the transit system they have out there, which is MTA. And I worked in the office. And I believe that's it. So hopefully, you got to see a little bit or know a little bit about me. And we're going to go into cheat sheet. Now, cheat sheet, where I'm going to give you legal tips in layman's terms. So I'm going to give you 3 of them. First one is, if you are going to have a consultation with an attorney, please be prepared. Come with your questions, come with your documents. Attorney may or may not read it during the consultation. However, come prepared, don't wing it. Use your time well and efficiently. Second one is be honest with your attorney. If the attorney takes on your case, you have attorney-client relationship at this point, be honest with your attorney. They cannot recover from a surprise later on down the road, especially if you're in court. Be honest with this person, okay? Third one is read your documents. When you get your new job, yes, beautiful salary, love the job description, okay. But those other documents that you are signing, and you're agreeing to, those are the terms of your employment. What you can and cannot do, what the employer can and cannot do. Read them, understand them, because when you sign it, that's what you're agreeing to. So if you have more questions on employment law, you can either contact an attorney in your state or you can contact me. My law website is www.mcblaw, as in Paul, LLC.com. My office number is 240-230-3633. Well, I hope you got enough information. Definitely check out Under Oath's website, which is www.mbounderoath.com. There you can submit your questions for office hours. You can submit questions for Plead the Fifth. You can also submit your answers for jury duty. And don't forget, just because you're watching the show now, that does not mean that you cannot submit your questions on these topics and subjects, even ones that have already played. So please submit them. Check us out on social media as well. We're on everything. We're on Twitter, we're on LinkedIn, we're on YouTube, all of it. Just look us up and subscribe. So that way you get all these legal tips and legal information. So I'll see you next time.